Good morning.
I see Mr. Nation and I see Mr. Ferriara. I messed it up. How do you pronounce it?
It's Ferreira, but it's okay, Your Honor.
Faria. I'll try to do better when I call you to speak. Mr. Nation, you may proceed.
Yes, Your Honor, if I can reserve 5 minutes. Thank you. May it please the court and counsel. As the court knows, the summary judgment was granted against my clients by the trial court. From the record, we were able to demonstrate in this appeal that there were significant issues of fact that should have been left to the jury to decide. And I'll start with this fact. The corporate representative, Wilson, in his deposition stated, Citizens does not dispute that there was a loss. And they said that twice, and that's page 903 of the record. And they're not disputing that a loss occurred. What happened?
I think that, Mr. Nation, I think that the real issue here is not whether a loss occurred, but what loss was reported and when was it reported. Let's talk for a minute about your client's deposition.
Yes.
He testified that he had done a bunch of renovations were necessary as a result of the July 2018 water escape. He had documentation of paying contractors for that, and that he had made copies of that documentation and sent a set to Citizens. And then he testified that he had the documents. He testified, and this is in September of 2019, that the plumbing worked well then. And when we get to the summary judgment hearing, what Citizens has been thinking all along is that it's dealing with the damage claim associated with these renovations that your client said he would give the documentation of, but then ultimately was unable to. Judge Holder asked about that. There had been an order compelling him to produce the documents that he testified in his deposition existed. So now we get a few days before the hearing and your client doesn't have the documents. And now we have all of this information about the cast iron, what was wrong with the underlying claim. And at the hearing, Judge Holder asked you, we were identifying issues of fact for Judge Holder, and you took the position that a fact issue exists with respect to when the notice was given, whether it was the notice that was given in July of 2018. I think you said, was it reported September 5th, 2018, when he says he made the report, or was it November 14th, 2018, which by then was, I think his counsel had already gotten experts engaged to look at this. But here's the thing, at the end of it, the only evidence that Citizens has, or the only way that Citizens can evaluate the condition of the cast iron pipe system is many months after the loss occurred, the July 2018 loss occurred, and after extensive, by your own client's testimony, renovations and repairs had been made. So doesn't that create a unique set of facts here where Citizens, is trying to process one claim, finds out it's at the 11th hour that claim has been disavowed, and relates to a bunch of, after the fact loss analysis of it, what sounds like an altogether different claim.
And I will address it. They had taken the deposition, I think, 5 months before summary judgment, took the deposition of our expert who told them what the cause of the loss was. There is nothing in the record, and I know they've talked about it significantly, nothing in the record that says this was a supply line claim. And nothing at all.
Is there a sworn proof of loss in the record?
I don't recall. They haven't raised that as an issue, but I don't recall.
I looked for it and couldn't find it, but the record, the summary judgment submissions are huge. So I had trouble being absolutely certain that I couldn't find a proof of loss.
I don't recall one way or the other whether it was or was not done. But this was, and as I got ready today, I thought we're going to be talking about a lot of facts. This was a drain line claim from day one there's nothing in the record where there's no citation they have that says it was a supply line claim.
Let me interrupt on that, because your client in deposition did say that water was coming out from the top of the toilet and out of the bowl, which does suggest a supply line issue. And so I'm not certain that the fact that there was leaking underneath, that it was clear from what he believed that had anything to do with the fact that the toilet was overflowing, right?
Yeah, there are three ways the toilet can overflow. One is supply line. Another is if you're running somebody's taking a shower or somebody's washing clothes, you'll have a backup coming up through the toilet, or somebody's washing dishes or using one of the other systems in the house. A lot of these occur when there is somebody turns the washing machine on, they leave the house, they come back and it's full of sewage. Same with a dishwasher. But I do want to get back to the report of the claim, because he is clear that he reported the claim immediately, but was told by citizens their system was down. And that's in his affidavit. System is down. He did do some repairs. There is no claim in this file for any of the repairs.
After he was told the system was down, when did he next attempt to contact citizens?
I think,
if I recall, it was about a month later, a month and a half later.
it was early September, I believe it was. And then November 28th, ultimately got a hold of them.
Mr. Nation, I want to take you back just for a minute to
Yeah.
follow up on something that Judge Silverman asked you about on supply line. At what point, I think where this becomes clear from your client's perspective, that this is the pipes, the cast iron pipes issue, is with the benefit of either Chicnosky and or Jeremko's inspection. Which of are those both your client's sort of best evidence of this is a cast iron pipe problem, not a supply line problem?
They had offered opinions as to the causation of the loss at the house, both above ground and below ground loss.
And they both, if I'm not mistaken, they both agreed that there was a problem with the below ground with the pipes.
Well, yes, absolutely.
Okay.
With the
And
pipes.
so wait, stay with me.
I will.
The Chicnosky first inspected the property, and it seemed like a superficial inspection in September of 2018, and then did a far more detailed inspection in 2020. Jeremko inspected the property in 2020. Both of those, all three of those inspections were several months after, and principally a couple of years after the original loss, if you will, and were all done after there had been plumbers out there working and doing the repairs that were subject of the claim that your client submitted and then withdrew. So that is a problem.
That's why each one of them addressed the fact that this condition in the pipes is very slow to occur. And they both said that the videos they saw of the interior of the pipes the condition was substantially the same as would have existed in July of 2018.
But then we have to reconcile that with your client testifying in September of 2019 that the plumbing was working fine then. And I reduced to, woman on the street terms, my question is, your client submitted one claim. It ultimately turned out to be difficult for him to get where he wanted to get with citizens, and he couldn't produce the documentation of it. And now your client may have another claim for another loss, but it hasn't been submitted yet. That's a very, not within the strict confines of a summary judgment analysis, but just as a practical matter here, one way to look at this is these experts identified and have opined that the cast iron pipes have been deteriorating for quite a while, but citizens has no way after all this time and the go back on it with your client's repairs. And it calls to mind the situation, which I think is generally espoused in case law, that post-suit discovery is not the same as pre-suit compliance with post-loss obligations. And here, citizens didn't disagree that your client had a loss. Your client had some problems complying with his post-loss obligations to provide information about his expenditures and so forth. But if the claim here is really cast iron pipes, I'm having difficulty seeing how they get tied to the loss that was reported as of July 2018, based on the timing of how these problems were identified.
Right. From the beginning, he reported water damage. That's what he reported. There is nothing in the record that says it was a supply line claim. The only evidence is that it was a result of the cast iron pipes. Citizens had the ability to go out and did go out. They found water damage. Our experts say the cause of that water damage was the cast iron pipes, creating a factual issue. We then jump to cooperation. Was there any cooperation? So under Curtis, if there's any cooperation, it becomes a jury issue. Then the issue is whether or not there was substantial prejudice. And Judge Holder did find that the notice, he didn't grant their summary judgment on notice. It was granted on the two things, repair.
I agree with you that notice is out. The only relevance that notice might have would be, and I think your opponent has acknowledged that, and I think Judge Holder acknowledged that notice was not the basis of the ruling.
Right. So repair and cooperation. There is some cooperation. We put in evidence that there was some. That's all. That should be off the table. Should be a factual issue. Then it comes to the repairs. Some of the things above ground were repaired. No question about it. Some were. We're not making a claim for any of them.
We don't really know what was done at all because your client can't produce. Your client testified that he had plumbers do work. They got underneath the house. And now, even though he testified that he had the documentation reflecting that work, we don't have the documentation of that work, which leads me to the question I wanted to ask you. And I'm sorry I've been all over your argument, but I think you asked for it. So what exactly would you say is the evidence of cooperation? Because we know that all the material that was ripped out was thrown away. That's been a beef for citizens. And we know that your client wasn't able to produce the documentation. Those are both undisputed facts. What is the evidence of cooperation that your client has affirmatively put into this record?
Yes, Your Honor. And that's in his affidavit spelled out clearly. He went to Kinko's on Dale Mabry, which is a FedEx facility, really. They own Kinko's FedEx. He mailed it. Doesn't have so that's one thing. And then he also, and this is, I'm sorry to keep coming back to this, but it troubles me. His affidavit also says that after July of 2018, the property experienced, and I'm quoting, additional plumbing issues. He doesn't say when, but he testified in 2019, more than a year before his affidavit, that the plumbing was working fine. And then another now 2.5 years later from this original occurrence, he's saying that the property has experienced additional plumbing issues, which that's a different issue than what I asked you about, which was his evidence of cooperation. And I want to make sure I understand. Your evidence of cooperation is that he mailed the stuff to Kinko. He made copies and mailed things to Kinko's, but then he couldn't produce the originals or the copies. The whole reason to go to Kinko's and make copies was so he would have them, and that's what he testified that he had. And then he didn't have those. So that's one evidence of cooperation. What other evidence of cooperation did your client affirmatively put into the record? He allowed them to come and inspect the home. That's another piece of evidence. He provided them anything they asked for that he had in his possession. He has said he has sent to them. He has given them the names of all of the vendors who went to the house, the work that they did, the amounts paid to them. He's done everything that he can do. And this all becomes, if there's any cooperation, this becomes a jury issue. But I do want to, as to the repairs, there was damage that Mr. Bickford, the field adjuster, found, water damage at the house. We have pictures of the water damage to the floor. We have pictures in the bathroom of water damage. Our experts say that's a result of this overflow. They chose not to investigate them. They hired no professionals. He went out, he took moisture meter readings, which are our side did too. Both sides recognizes finding out moisture, whether or not moisture is wicking up through the floor from the failed system is important. He took those readings. He didn't photograph them. He said they were elevated. He didn't photograph them. He didn't say where they were taken from. We documented those. We documented through hydrostatic tests and through videos the condition of the pipes, all leading back to fact issues. So unless there are any other questions, I can check my notes, but I believe that there's a fact issue as to cooperation, fact issue then as to whether or not there's prejudice. Our experts were able to determine the cause of the loss, the extent of the loss, what the repairs should be, and the cost of those repairs. They chose not to do that and instead said, well, they chose not to investigate that and just said, well, we're prejudiced. And then as to the damaged property, we are not claiming any of that stuff that was damaged. There remains items there that have not been repaired in the document water damage. Thank you.
Very good. Thank you, Mr. Nation.
Thank you.
Mr. Fredea.
Good morning. May it please the court. I think it's really important for this court to understand the timeline of events. And I know that you have already gone over some of them with the opposing counsel, but I'd like to start out with, we know that around July 30th, 2018, a loss occurred. There's some issue with the water coming from the bathroom. 4 months later, we have the first tangible and concrete and unequivocal piece of evidence that some notice was provided to, and I know notice is not an issue, but I think it's important for the timeline of events. Where Citizen is provided the information that a loss occurred. That was November 14th. That same day, Citizen sent out certain letters out, 2 letters. One of them advising the appellants what their duties are under the policy to keep to keep it repaired, anything that's repaired, any of the items that have been repaired, to keep it, to preserve it, as well as the homeowner's claims bill of rights. November 20th, we have the 2018, we have the inspection. At the inspection, the appellants say, we have these documents, we have these photographs, they support our loss, we will provide them. November 20th.
So Mr. Is it Ferreira?
Ferreira.
Ferreira, okay. I've spent a fair amount of time reading through this timeline, and here's the problem that I think we have in the procedural posture that this case is in. It's very difficult not to see this case in the circumstance where the trial judge effectively judged the credibility of the plaintiff, because we all agree there was a loss. We agree that, and I think your opponent did a good job of outlining what the evidence of cooperation was, and those create fact issues. And Judge Holder, at the hearing and in the order, essentially brushed whatever fact questions there were aside, and I think he used the language to the effect that unique circumstances of this case. And one fair read of that on the back end of a summary judgment is that he made some credibility determinations about whether the plaintiff was sincere in riding the horse that it brought out in somewhere between July and November 2018 over the finish line in 2020, because it had withdrawn, didn't produce the documents that allegedly it had, et cetera, and then disavowed that claim. It looks a lot like a credibility resolution, which is not something this judge could do on summary judgment. And that puts it, if you accept that puts us back in this legal world where, there's some evidence of cooperation, so we've got a triable issue. There's the presumption of prejudice may or may not apply here, but if it does, we still have a triable esse on cooperation, and arguably citizens would be required to show prejudice anyway. And that's a troublesome situation for you.
Well,
what say you?
Well, I submit that there is no credibility determination, because what we have here, and I think the gist of the cooperation really revolves on whether these documents were sent to citizens or not. And if you look at the affidavit that was filed, it doesn't state where they sent the documents to. It just says we copied these documents and we sent them out. Now, okay, well, what documents were sent out? Where did you send them? How did you send them? And not only that is, well, what happened to the documents? So what did you do? Did you send, you went to Kinko's, did you make copies and sent the copies? Or did you send the originals and the copies? There's nothing there. So I don't think there's a credibility issue whatsoever because there's no evidence.
Well, I think from viewing it in the light most favorable to the plaintiff, which we're required to do, the plaintiff's testimony in the affidavit is that he sent a compilation of documents concerning the loss and the repairs that were made.
Yes, Your Honor.
To citizens. I mean, he didn't send them to the North Pole.
No, Your Honor, he did not. But if you look at our brief, we actually addressed this issue. And one of the reasons why I point out that there is no address whatsoever is if you look on page 28 and 29 of our brief, we go into that the documentation was never provided. And if these cases that we cite stand for that proposition, there's a presumption that when you send something by the mail, it's arrived and it was received. But the cases that we cite, and one in particular, and I believe it's the I apologize, Your Honor, it is the Star Lakes States case, and it says, and let me quote it: proof of mailing normally raises a rebuttable presumption that mail was received, but such a presumption only arises when there's proof that the mail is being sent to the correct address. And we don't have that here. There's nothing in the record whatsoever that states that Mr. Lopez or Ms. Lopez actually sent these documents to citizens.
So
isn't that argument that you're making exactly a credibility argument, that he says he sent them, he didn't really give us enough information to make it believable, therefore he shouldn't be believed?
No, because under the case law, there's the presumption. The only time you have a presumption that it was correctly mailed is if you have the correct address. That's not what we have here.
So what you're arguing is his affidavit is insufficient to create a factual issue on that.
Correct, and that there's no record evidence that it was actually mailed to the correct address. That the documents were actually mailed. There's no evidence. There's no concrete substantive evidence that it was actually mailed. And Your Honor, and I understand that plaintiff also cited the inspection as cooperation, but let's face it, when our adjuster went to the inspection, everything was repaired. He noticed that the pipes were brand new, there was no leaking, the flooring was repaired. The inspection there was no reason for the inspection to occur, to be quite honest, because everything had been repaired. So the only 2 points that they have that there was cooperation was the mailing of the documents, which there's no record evidence that it was actually mailed, and the inspection, which was not an inspection at all. So if we don't have an inspection that really inspected anything that was damaged, any of the loss, any of the pipes, and we have no evidence of this mailing, then there is no cooperation, and as a matter of law, there's prejudice. And I'm not sure if I think that's our argument. That in a nutshell, that's really what our argument is. And unless you have any other questions, I'd rest on the rest of my brief.
So I want to ask you one more question about this,
Sure.
the documents, because in the deposition of your client, he says he received a request from citizens. We were able to comply and forward back to citizens. And the one that she has the numbers and all that. We did it off of that. Do you know when, after receipt of this letter, all the documents were provided? I would say less than a week, because I had to take her to Kinko's right off of Dale Mabry, Spruce and Swan to make copies, cost $21 and so forth. Was there any question asked at the deposition about, do you know what address you sent it to? And the reason I ask that is I don't think that question was asked, but he says that he sent it in response to the letter, which does raise an inference that I complied with what the letter requested. Now, that may be a stretch of an inference, but again, it does seem to go to a credibility question.
John, I would say that inference is no inference at all. And to be honest with you, I don't believe it was asked. All I can tell you is that the whole basis of their, and if you read their brief, the whole entire basis of the cooperation argument is really based on the affidavit of Mr. Vincent Lopez. And you can, I think it's on page 12, 13, 18, 17, all those pages where he just says like, well, there's cooperation, and he cites his affidavit. Well, that's his opinion that there was cooperation, but, and again, I hate harping on this, but where was the document sent?
Let me ask you a question about the cooperation. If the documents that he was sending were pertinent to the claim that ultimately was disavowed, what effect, and help me out making sure that we understand what the documents, my understanding of those documents, and I'll put this to Mr. Nation as well for rebuttal. The documents that he would supposedly sent were documents pertinent to the repairs that were made immediately following the July 2018 event before the repairs were done.
That is correct, Your Honor. It's my understanding, and as well as
And
photographs.
if those documents went to a claim that he disavowed right before the summary judgment hearing, in what do they in any way, and again, I'm setting up Mr. Nation for rebuttal here, what effect does that have on whether there's a fact issue regarding cooperation?
I don't believe that there's a fact issue, and the reason for that, Your Honor, and I apologize, we did not cite this in our brief, but it's the case law. I think it's clear that when you move for summary judgment, you're basically, you only have to move for summary judgment on what's alleged in the complaint. And if you look at the transcript of the hearing, the judge actually chided appellant's counsel.
But the complaint didn't say supply line issues either. It just said water damage occurred.
Yes. And it's just this amorphous, just general description, Your Honor. And here we are about 3 years later, the supply line issue, and that's the only testimony that we have in the deposition of the appellants. And then basically about a week before the summary judgment, well, they disavowed that. I mean, they're switching their position, in order to rebut the summary judgment. And again, the case law is saying you can't do that.
One last question from me, at least. The transcript of the summary judgment hearing is pretty short and perfunctory. There doesn't seem to be any objection to the testimony or the evidence provided by the claimant, by the plaintiffs. Did I miss that, or was there in fact no objection to what was before the court?
John, I don't believe that there was an objection, and you would be correct in that.
Okay. Unless there are any other questions. Very good. Thank you. Mr. Nation, you have your rebuttal time.
Yes, thank you. And I'll get to Judge your question. I would point out in the affidavit, paragraph 7, Mr. Lopez's affidavit, he said he got the letter from Citizen, the date it was, collected the documents, went with Ms. Howard to Kinko's, sent the documents we had in our possession to Citizens. It says it right in there. Based on the letter, the 11/28/18 letter. So the deposition of our expert took place, I believe it was 5 months before the summary judgment. This was not a new issue. The claim was for water damage. The pipes is the cause of that loss. And that's what we went to summary judgment on. And now we have a factual issue on cooperation, as well as the effect of repairing some of the damage that's not being claimed. I think the court, I would hope recognize those are factual issues. There's a case, Farmer versus Allstate out of the 5th. That's my case. And the issue that went to trial was Allstate said my client never sent a proof of loss. And he testified he did. And the jury determined that he did not send a proof of loss to Allstate. But then the second question is prejudice. And they also found Allstate was not prejudiced by that. But we have the similar situation here. And that was the appeal, that was the issue on appeal in Farmer. So unless there are questions.
Well, at the hearing with Judge Holder, you took the position that you had summary judgment evidence that the pipes caused the failure. That evidence was evidence that was assembled at the very earliest, giving the affidavit of Chiknosky the credit for having inspected the property in 2018. Other than that, the summary judgment evidence that you provided came from reports that were prepared from inspections that were done in 2020. And that does raise a question about what Citizens was on notice of and supposed to be inspecting.
Well, Chikonsky, they videotaped the lines, they have photographs. That is the evidence.
In 2020, though, that was your summary judgment evidence. It was 2 years, more than 2 years after the event. They brought in evidence and said, now we're not seeking recovery of the replacement of the flooring and all the things that the water damage originally caused. 2 years later, we figured out that the real problem is the pipes, and that's what we're claiming
As the cause of that loss. And they went through and documented in both affidavits.
And presumably the reason we're still here is that your clients now would like to have Citizens replace the pipes, right?
Well, not replace them, but get access to the parts that caused the loss, access to them. There is a video, just so we're clear, taken 9/14/18 of the inside of those pipes. There was another video 10/12/20. The condition of the inside of those pipes had not materially changed, and we dealt with that in both affidavits of Mr. Chikonsky and Mr. Jaremko. But the video of the inside of the line was 9/4/18, and that was in the record. Photographs of the home were 9/4/18. The report by Mr. Chikonsky's company was 10/21/18. And so, yes, Mr. Jaremko also did videos later, but there was no meaningful difference because this is a problem that occurs over a very long period of time. But I wanted the record to be clear. Videos were right after the loss, photographs right after the loss. Again, Citizens could have done the same thing.
But the first time Citizens saw those videos, because, well, did your client testify that he sent the videos to Citizens?
I don't know.
Is that part of what went in the Kinko's package?
I doubt it. I doubt it.
Because otherwise, the first time Citizens is getting the videos is with the benefit of the expert analysis 2.5 years later.
I'm not sure when they got it. If they did ask for a proof of loss at that time, they would have gotten them. But I don't know. I don't know that that's in the record, one way or the other.
Mr. Nation,
right.
about
Yes, sir.
30 seconds to wrap up.
I don't have anything else, and unless there are questions.
Very good. Thank you both very much.
Thank you very much.
That concludes this session of our oral argument docket. You all have a good day, and thank you again. We're adjourned.
Thank you.
Thank you. Bye-bye.